Identifying that micro themes is very essential. And if you would have seen my notes as well, I had these one-pager notes which I had made throughout the preparation time that I was delving for mains and after the prelims results as well. So those one-pager notes were based on the micro themes which are like very repetitive in nature. I'm not doing a post-mortem analysis where I went on and asked and found out the court judgment so that I would be able to deliver something, but this are something which I took from my own notes. And then you have a lot of points and your dimensions, like it's a 10-marker question, 2 perspectives you're giving. Ideally, minimum you should have at least 5 plus 5 dimensions plus the value addition stuff to make a more wholesome answer. There's a AI spring. And you can always mention certain terms like this which are catchy and which the examiner would find also relatable. So these are the smaller X-factor things where you put in the actual sections of these bills, where you put the any political scientist names or these very to the point conclusions which are value-added code. That would make a difference, and that's what we cover in the Smash Mains notes and the model answers of the FLTs. Hello everyone. So a couple of weeks back, we introduced you through a video about Smash Mains, and we have been continuing with the same from 25th of June. And so I thought I'll come up with another video where I explain that what actually has been my involvement and what actually with the CD core team and my involvement being there, what the things that we have done and what we're trying to do with the program. And also in an essence, through this you'll also get an essence that what is desired through the mains rigorous practice that you would do, what should the desired outcome you should get, so that that outcome, if reflected in the exam D-Day, that would fetch you, the probability of you fetching the maximum marks gets quantified in a much more profound way. So through this, like couple of things before we delve into the actual subject of this video is that there are a couple of things on which Smash Mains program, in my opinion, has helped me, and that has been even made more streamlined this time. So UPSC, if you see, especially when we talk about prelims, is too random. It talks about literally everything under the sun, in spite of there's being a syllabus, but that syllabus also kind of caters to everything. But in mains, there's a detailed syllabus to that. And for every detailed syllabus keyword we have, there are a lot of micro themes. And identifying that micro themes is very essential. And if you would have seen my notes as well, I had these one-pager notes which I had made throughout the preparation time that I was delving for mains and after the prelims results as well. So those one-pager notes were based on the micro themes which are like very repetitive in nature, and in general may not be repetitive, but those are the existing micro themes for a particular keyword of the topic. So the idea is that you should have ample amount of dimensions in that particular micro theme. A lot of tangents knowledge you should have that can be drawn for that particular micro theme, so that you can build up on the content and you can reflect the same in the D-Day. So the idea is that if I have a micro theme as something as justice or criminal justice system, you can have a lot of tangent for that. You can have what are the current legislations on that. You can have a micro theme on how the criminal justice system is reforming. You can have one as the loopholes in criminal justice system, and one the basics why, hows, and stuff like that for the same. So for one topic, these could be different tangents on which we're trying to identify the micro themes based on the PYQs and the general trends of the mains examination, and building content through the Smash notes. And that is what also we're trying to test through the test series as well. And this test series attacks on these micro themes and ensures that the representation of the questions is in a way that the micro themes get populated in your tests as well, similarly, so that you get the essence and the test of these micro themes that get repeated across the years. And what is also I've given a lot of importance is the kind of wordings or kind of the way the questions are being asked, that's also are in lines with how UPSC has been asking questions. You'll see in this example also, no one asks you about what are the issues with election commission in India. They add a very generalized statement which seems a bit abstract, but you have to understand what is the exact demand of the question, and then probably interlink few things and then write the major crux of the topic. So that is also the one of the objectives, that our wordings has to be in a similar way. And the third and most crucial part is to having the breadth and the depth of the content for all these micro themes. Because at the end of the day, if you are prepared well, then and you have like let's say 15 dimensions to that you have internalized, you'll be able to reproduce, let's say 10. And if you would be internalizing 10 dimensions, 10 tangents, you'll be reproducing, let's say 7. Because it's always, you will be like, the way you are preparing, it's very difficult to reproduce the same thing in the examination under examination conditions with a lot of pressure and with a lot of time constants in place. So it's important to have everything, like all dimensions, as many dimensions possible, internalized and on your fingertips. So that is also one of the core ideas and the core philosophies on which the Smash Mains has been built on. And that probably differentiates between somebody who is an amateur and a beginner and somebody who is a bit veteran and seasoned, and also to get that X factor and bit higher edge while you're writing the answer. So today's video will be, I'll take a few questions that we had in our FLTs, and I'll try to show you that what kind of multiple dimensions you could have had with those X factor content, in my opinion, where I as an aspirant would have tackled this in a way. So I hope that would be helpful, so that that would help you to widen your horizons while answering a question. Also would also help you to understand what kind of depth also the exam is looking forward to. So the next question here talks about the criminal justice system and the three new criminal bills that have been passed, and extremely essential, very high probability that this could come in this year mains as well, because that has been a point of discussions too. So when you're talking about criminal justice system, it straight away asks you what is criminal justice system. So for that, I would not recommend you to give value addition stuff, because it is directly asking about what is criminal justice system. So your introduction should be explaining in a line or two what is criminal justice system. You talk about, give a more nuanced definition that criminal justice system is about the institution, processes, laws that govern the entire paradigm of criminal justice in the country, that caters to prevention, detection, prosecution, and delivering of justice and punishment in cases of in the areas of criminal justices. So something like this could be a generalized definition, because it is asking you a definition of that. So that solves your the introduction problem. Then it is asking in what ways new criminal law reform bills have unshackled the Indian criminal justice system from its colonial legacy while keeping the focus on justice rather than punishment. This is something we read, like I would have attempted as an aspirant, is that there's in my notes also, I had Michael Foucault stresses that justice system should change from repressive to restorative, and the three new bills, which are BNS, BNSS, and the three bills that you mentioned, are also envisioning on this idea. So this is how you bring one academic approach. You mention the three bills that has been passed already, and then you shift on to the actual content, and it's also 15 markers. So you can do a bit of context building also in one line or so. So that is how I would have introduced, by giving one academic philosopher. He's a political scientist, borderline political scientist and sociologist. So that is what I would have given his name as well. Then I'm asked it's asking how it is reforming, like how this is being done from repressive to restorative. It has to be your answer. So for that, for the BNS, the Bharatiya Nyaya Sanhita, you can give 3 different ways that the 3 different laws and 3 different laws ka what are the aspects which is catering towards the reformative way, you can do that way. So if in BNS you see, there's an abolition of sedition, which was a part of the section 124A of IPC. Then we have the provision of community services, which is aligning with the idea of reformation and forgiveness as a principle being given more priority. Then we have attempt to commit suicide is taken away, is no more a criminal offense under BNS 2023. Then we have also the terminologies like unsound mind, has been replaced with mental illness. To bring in sensitivity in the way the law has been drafted as per aligning with the Mental Health Act 2017 as well. So here you put 4 or 5 points here, and then in BNSS, the Bharatiya Nagrik Suraksha Bill, Suraksha Sanhita, there what you can have a couple of points where you mention and provide this idea where you say that there is electronic form of FIRs and summons are allowed. That ensures that the way in our criminal justice system is reformed so that there's ease of doing businesses more and people do not have a lot of inertia while dealing with the criminal justice system. The provision of zero FIR, where no matter at what jurisdiction where the crime has been committed, anywhere that can be reported at any police station, and then the other processing would be done. Earlier, there was no provision for the same. So it's a procedural help that helps in reforming or restoring the criminal justice system as well. You can always write a point how this is very victim-centric. And you can prepare a bit well also for topic like this, the particular sections as well. For example, there is a section 193.3 where it tells that if there is a complainant or the victim themselves would be updated about the status of their cases within 90 days of putting that complaint. So it makes the entire paradigm very victim-centric too. There is also section 398 that talks about witness protection. So there's a codification on the witness protection as well. And you can talk about the other bill as well, how there has been acceptance of electronic media, electronic form of evidence, oral evidences have been also institutionalized. So that also improves the way the criminal justice system is transferring to the reformative form. And you also cut kar sakte, right? And also there's one more section of 479 about bail. there's a lot of couple of court judgments on how it's essential that the number of under trials are increased. Like there's a huge proportion of under trials, around 70% of prison is filled by under trials, and a lot of court judgments for that. And then give that key in section 479, there's a leniency in giving the bail, and now the rule is that if you have served 1/3 of your detention period, then there is a provision where you can serve a bond and then get a bail. So getting bail has become more easier. So that's also about the reformation, which is essential to note. But since it's a 15 marker, we'll have to also show that there is still a gap, that we have not like transformed from a punitive to a more reformative way of criminal justice system, and that you'll have to also show, because it's a 15 marker. So this would cover, the first part would cover around 10 to 11 points, and next you'll have the issues that still the bills have. The first generalized issue is there's a lack of representation, lack of consultation, which did not take into account of the opinions of NGOs, civil society, judiciary, bar, so on and so forth. So that's also one of the constructive criticism that you can give. Then there's a section in BNS that talks about that there is a provision for punishment if any act endangers the sovereignty, unity, and integrity of the nation, which is more or less how the sedition was also worded. So there is also criticism that political thinkers give that in a way sedition has not been entirely removed. There's another in the Bharatiya Nagrik Suraksha Bill, where there is also that the confessions that has been made before the police, that like somebody who has been taken into the police custody, so their confessions has also been agreed as one type of evidence. So what happens, because which comes under the section 27A. So what happens? Sorry. So now it will lead to more custodial torture, since whatever you say in front of the police has also been institutionalized as one of the evidences as well. There's another criticism as there are a lot of social welfare offences, but there has been no codification of the same and no definition of the same. Then a lot of generalized points you can give. In criminal justice system, in spite of all these bills, there are a lot of institutional bottlenecks. There's no modernization of police forces, the amount of budget that they have, the representation of women, the shortages of polices, the data for that, everything. That could be also one of the points. You can always talk about the number of under trials. Still, even though there is a leniency in bail, but bail still remains one of the contentious issue, and that's why the proportion of under trials are not reducing. Another constructive criticism is that there's non-codification of a lot of directives by the Supreme Court and the High Court. So, for example, there's a court judgment in Satinder Anil versus CBI, where the court has said that they may decide on the bail of the accused in his presence without taking him in custody as well. So a lot of similar directives by the court has not been codified in the three laws where that could have been as well. Another constructive criticism is that the age of criminal responsibility has been retained at 7 years. But if you see the other international conventions, it is much lower. So that's also one of the constructive criticisms over there. The second question being, the digital India on the back of AI is the future of e-governance in India. However, improper setup of the e-governance structure can result in a variety of challenges, explained with suitable examples. So here is basically saying how AI is helpful for e-governance in the backdrop of the digital India initiatives that we are running. But in spite of that, our structures are in a way that particular thing has a lot of impediments that it has to overcome, and you have to give both the sides of the story. Again, it's an AI question, and AI is like literally there's a AI spring. One second. there's a AI Spring, and you can always mention certain terms like this which are catchy and which the examiner would find also relatable. So you write anything about AI, either a quote or a data. There's a lot of data which should be in your introduction, like one by Niti Aayog that says that there will be a 15% addition to the gross value addition by 2035, or one by Accenture. I remember I had in my notes as well, where it says that close to 1 trillion economy will be added to Indian economy by 2035. That could be your introduction. Or there's a lot of quotes that Honorable Prime Minister keeps on saying in various summits about AI. So you can take up few of his quotes and quote it multiple times, where one he has said that AI goes beyond economic progress and helps in delivering equality and social justice. So this could be in a way of one of your introduction conclusion. If you're making this as introduction, this could be a ready-made conclusion for the same. That is how you can structure. This could be your 25 words and this could be 25 words, and we're remaining with next 100 words. 100 words may 50-50, one for how it is empowering and one how there are the hurdles which are still there. But be very to the point. Like, I'll not write what are the initiatives about AI that India has done. Rather, I'll try to put that while answering how it is the future of e-governance. So every aspect of future, like now my answer would be like AI is future of e-governance in the following ways. And I give a thing like ease of doing business, reduces the manual work, automation, and give example of GPTs and things like that. Second, we have something like improved service delivery. So, for example, here I said ease of doing business, it reduces the manual work, automation, so on and so forth, and give an example of GPT and all. You can always write as envisioned by National Strategy for AI. So these are the filler things, but these are very institutional stuffs as well, because these are government policies and you do not have to mention that as a point, but in the existing point, just put in these policies at some places so that it shows that like the views that you are presenting are also in line with the institutional apparatus that the government has already created. So that will give you those value addition stuff as well. And these are the small X factor things which makes a lot of difference. Improved service delivery. You can always give an example like AI based chatbots. One I remember was there was an AI chatbot example for PM Kisan initiative, where farmers, when their vernacular languages could converse about the benefits about the scheme and stuff like that. Then enhanced decision making. Here you can give an example how AI has been used in Ayushman Bharat case, like Ayushman Bharat initiative, where a lot of bogus targeted beneficiaries were ruled out because of the fraud detection systems and other things of machine learning and AI. So that is how service delivery was also improved. Fourth being obviously cost effectiveness. I remember we had an example on AI. This had given something, Project iDrive by Indian Oil, which optimizes the costs of the plant and stuff like that. So a lot of your things that you might not have read in books, but in your general news, say, or general movies or things like that, because I was an employee at Indian Oil, this is something that I knew. So that also helps. You can put in relevant points according to your own experiences too. The fifth point could be also about the financial inclusions, where the beneficiaries could be targeted in a more streamlined way. Then you can always put the point of urbanization and smart cities, where data analysis could help for reducing traffic congestion, for waste management and stuff like that. We had a scheme of for reducing the burden on discoms, where you have these dynamic pricing for the electricity bills that takes into account a lot of AI as well. Then you can talk about also a lot of, like, you have read about initiatives like Microsoft doing something for reducing the dropouts in Andhra Pradesh. There's a scheme of Telangana, Sagu Bagu, which uses AI for agriculture. So in all of these points, you can mention those things so that you get that X factor marks as well. In the second part, where you have to say that what is the improper setup of e-government that result in variety of challenges. I'll tell how, like, there could be n number of challenges which you could comprehend, like which you could enlist. First, obviously, being there's a digital divide that comes to a mind, where digital divide in terms of men and women, digital divide rural and urban, and you give data for that. Then we have data security in the absence of true execution of data protection bill, privacy concerns, and data sovereignty being a concept. That's the second point. You can have like 2-3 points on data sovereignty, data localization. It could be 2 points as well. Then third point, we do not have good data quality as well. Our e-governance structure is that we do not have good enriched consolidated data. And give an example, in spite of Niti Aayog's national data analytics platform, since the data quality is not as high as it is required, a lot of analysis could not be done. You could have another aspect, how data is in various silos. So data accessibility is an issue. The sixth point could be the lack of R&D. The investment, less than 1% of GDP goes into R&D. Then again, you have human skills which are deprived, like the lot of dearth of human skills. So people are not trained, so on and so forth. Then there's the issue of IPR. We do not have robust policies for that. People are not aware about their IPR and the allied areas. You can also have that, in terms of research, you can give data about the kind of citable documents China has as compared to India. So value addition stuff from those point of view. So there itself, you get around 8-9 points itself. So this is the depth and the breadth of points what I'm talking about. And then in the end, you can give way forward me. Like UK has something called Turing Fellowship, where they're exclusively training people and giving fellowship for PhD scholars for AI. Similarly, UAE has now Ministry of AI. So this could be a way forward, just do wordings pe, and then you can give a conclusion by Honorable Prime Minister's quote or thing, like you can just mention there's a committee, Kamakoti committee, which has recommendations on AI. So just mention that committee as well. So this is how you make your answers more wholesome. Yeah. So this question talks about preventive retention reflects the tension between tension between the state's duty to protect and the individual's right to be free from arbitrary detention. So basically, it's asking you, there's a tussle between states' own onus for the protection of the self, like the state's protection, the national security and everything, versus the individual's freedom and individual rights and everything. So there's a tussle. But the major theme here is a preventive detention being the point of contention. How do you write it? So a lot of copies and a lot of aspirants that I know would start with saying how preventive detention ka definition, which is basically ki preventive detention is where people are taken into police or judicial custody or police custody where before they would have committed a crime, and in an anticipation that they might commit a crime, they are taken up to the bar before, like behind the bars. But that's very generic, and that's not how you would introduce a good introduce your answers, right? And couple of ways in which you can do it. Like the most important, like the very straightforward but still okay way is writing Article 22(3) and telling that Article 22(3) debars the preventive detainees from the immunities and from the protection that is granted on the basis of arrest as inscribed in Article 22(1) and 22(2), to show that there is a difference in the rights that somebody otherwise would get as compared to somebody who is under preventive detention, which is mentioned in Article 22(3) as opposed to Article 22(1) or Article 22(2). Or you can quote any of the judgments also for the same. A lot of them are important and which can be used for introduction is Shambhunath Sankar versus West Bengal. And this is not something that I'm making up. Like, I did not prepare this court judgment because I had to explain this to you. Because if you would see my polity notes also, which I have shared on various platforms, this court judgment was a part of it, and a multiple of them was there as well. So I'm telling that I had done a beforehand preparation which has helped me to answer similar questions. So it's not, I'm not doing a post-mortem analysis where I went on and asked found out the court judgment so that I would be able to deliver something. But this are something which I took from my own notes. So that's the idea also I wanted to pitch in. So you could always say in Shambhunath Shankar versus West Bengal, the judiciary accepted the essence and the necessity of preventive detention and called it that it might infringe upon the freedom of the rights of the people, but it is essential for the national security of the country. So that shows a judicial interpretation of preventive detention where it says it is necessity, but also accept that it infringes upon. So basically gives a context to what is asked in the question, but in a more value-based way. So if you're introducing with this, but also it's important to build up this Article 22(3) so that you make a context, like contextualize this. So this could be your second line, and then you tell that how there has to be two parts. The first part could be how preventive detention is helping the state to ensure its own duty to protect itself, and second, how it's also infringing upon the right of the people to be free from the arbitrary detention. So after this introduction is done, your first part becomes essential to answer, which is the state's duty to protect. So you'll have to write, like you can write preventive detention helps the state to ensure its own protection in the following ways. And then you have a lot of points and your dimensions, like it's a 10-marker question, 2 perspectives you're giving. Ideally, minimum you should have at least 5 plus 5 dimensions plus the value addition stuff to make a more wholesome answer. So the first could be the security of the state. And you write against the communal forces, against forces with separatist tendencies, etc., etc. And give an example of A.K. Gopalan case, which justified preventive detention for the cause of national security and the security of the state. The second could be a proactive crime prevention. This in cases where you want to prevent a mob lynching, where there's a possibility of communal riots. In a lot of that cases, preventive detention is extremely helpful. So that becomes another point of it. The third one, you can give judicial validations. Use another court judgment to show this. We had Mariappan versus the district collector, where the court has pronounced that it is again essential so that the societal benefit remains at large, and it's beneficial for the entire nation and for its own sanctity. So there's a judicial validation could be also one of the dimensions. You could have something as deterrent effect. And show that how preventive detention helps to reduce the domino effect of having these malpractices or all these evils, societal evils of separatism and communal violence or regionalism tendencies. So that could be helpful. And then you could also write significance of preventive detention legislations. Example, UAPA, where you can give ki under UAPA so and so such separated tendencies were restricted by putting such and such people under bars, and you can give those examples as well. So in polity also, when you are writing, like the framework which I used for generating more ideas were very simple. Is you can always talk about laws, you can talk about institutions, third, international convention, and this institution could be a constitutional or a statutory or non-statutory. And the fourth one was any judicial intervention. So this are your at least the 4 immediate frameworks through which you can generate your points as well. The second part of the question talks about that how it also infringes on individuals' right and individuals' freedom on those lines. You talk about how there's no objectivity on the grounds on which this preventive detention could happen. So lack of definition and codification. The second obviously is about how percentage of conviction is low. You can have NCRB data. Close to 80% or so have not been convicted yet. So that's the data that shows that the idea and the effectiveness of preventive detention laws is not meeting what it has been designed for. Third point could be gross increase in preventive detention. If you see from last year, there has been a 24% increase in preventive detention cases as well. That symbolizes that this could be used for a political tool, or this could be a more generalized way of infringing upon the rights and freedoms of the people. Then we have a point like the advisory body. And when you're writing that, like if you're preparing for mains, you'll be knowing that there's an advisory body which has to give a report within the 3 months. Then you can write in bracket like 44th Amendment reduce that to 2 months. But then you write that this is an entirely executive body, which well, the body is entirely elected by the executive. So conflict of interest and impartiality could be questionable. The fifth one, you can always bring in arbitration on Article 19 and 21, where human rights and a lot of these conventions you can mention about human rights, and so where you say ki this overshadows all these human rights and the fundamental rights are inscribed in Article 19 and 21. And then you can always also have a point like it's a colonial legacy. Where you say that and also show that it's a very rare case where a mature democracy like India has such a policy of preventive detention. And then you make a way forward. In way forward, write another court judgment, Ashok Kumar versus Delhi administration case, that has told that there has to be a fine balance between these two, and how more objectivity has to be mentioned and has to be ensured in the codification of the conditions on which preventive detention could be applied, and the advisory body concept and everything. You can give generalized feedbacks and generalized recommendations so that there's a fine balance between the two aspects. And the conclusion you can give from historical times. I mean, if you would have known a bit of context how this happened, just after our constitution came into enforce, there were a lot of bills like there are a lot of public safety bills like UP public safety bills, Bihar public safety acts basically, which were declared as ultra vires. And where the judiciary said that indefinite public detention, preventive detention without recourse of action is basic ultra vires. And similarly, from that time in 1950s to today, 2024, the same principle beholds, and there has to be fine balance between these two. So this is how you can have a more, with the instead of having a very generalized conclusion, you give a particular case and relink how this has been a contentious issue from 1950s to till today, 2024. So this is how you make your answer more wholesome as well. And then you can always end your answer with a quote or whatever it is. And it is desirable to have a lot of quotes on justice. There's a quote by Justice Iyer, where it talks the soul of justice is healing, not hurting. It's about reformation, not retaliation. And you can end your answer. So it's important to have these ready-made quotes about justice, federalism, separation of power, and such political theories. So justice being one of them, liberty, equality and stuff. And you can always use that as a ready-made conclusion too. So these are the smaller X-factor things where you put in the actual sections of these bills, where you put the any political scientist names or these very to the point conclusions which are value-added quote. That would make a difference, and that's what we cover in the Smash Mains notes and the model answers of the FLTs and or the sectional tests that people write here in the Smash Mains program. So thank you everybody. Hope you do really well.